Hi, everybody. Welcome back. It's Suddenly Single with Shira Raymond, and today I'm going to be interviewing Mark Hess in just a moment. Hi, so I'm really excited to have Mark here with us today. And Mark is the CEO and founder of Mark Hess Tax Consultancy Corporation. Mark has been a tax lawyer who specializes in divorce, taxation, and employee benefit matters. He was a partner in a large international law firm with over 40 years and started his own tax consultancy practice last year. Mark divides his time between Las Vegas, Nevada, and Jerusalem, Israel. So, welcome, Mark, to the show.
Thanks so much, Shira. It's a pleasure to be here and to speak to your audience.
Thank you. So, I know there's probably so many things that when women go through divorce that they don't even think about what it is that they need to look out for to protect themselves in the process. So, where should we start? I mean, what would you tell people going through divorce? What tax issues that they may need to start to think about?
Well, I think there's one overall takeaway that your listeners should get from our talk today, which is that just like all of the other divorce issues that get negotiated, tax issues also get negotiated, or they should. And if you have a good divorce attorney, uh, that divorce attorney will make sure to treat tax issues as issues that are of value to you and therefore to negotiate for the best possible outcome for you. Uh, Divorce lawyers who are not as familiar with tax issues should get a tax advisor to help them navigate those issues because otherwise they're potentially doing a big disservice to their clients.
Wow, so that's so interesting. So, what are some of those issues that might come up that a woman might need to start to think about and question that'll help protect them as they go through the process? Just make sure that their lawyer is doing what they're supposed to be doing.
Correct. Well, look, I mean, let's start with a one very basic issue, which is does it make a difference? Let's say a couple agrees that each of them should get $1 million in the divorce. Does it make a difference which assets the each of the spouses gets? And you might think, well, it doesn't matter if I'm getting value of $1 million, I'm getting it, and I don't really care. But the answer is, it can make a big difference from a tax perspective because of two different issues. Number one, there's the issue of tax basis. Let's say I buy 1,000 shares of stock for $20,000, and then 3 years later I sell the stock for $100,000. That's an $80,000 gain, which is taxable at capital gains rates. On the other hand, if I bought the stock for $90,000 and sell it for $100,000, there's only a $10,000 gain. Now, there's no tax when assets are divided in a divorce. And so, therefore, if I'm uh, let's say, representing a woman who maybe is not the bigger bread earner of the two members of the couple, I want to make sure that to the extent at all possible, she gets high basis assets because that way, if she has to sell the asset soon after she gets it, she doesn't have to pay much tax. She's getting the same value in each case. She's getting, in our example, let's say $100,000, but she shouldn't say, well, I like this particular stock, even though its basis is only $10,000, if she might have to sell it in the near future. And so that's a very important point that uh, as her lawyer, as a divorce lawyer, you want to push for her to get the higher basis assets. The second thing is that there are some assets that are before tax assets. As an example, an IRA account. Let's say the husband has a $200,000 IRA account, and he wants to give that to his ex-spouse pursuant to the divorce as part of, let's say in our example again, her $1 million. Well, the $200,000 IRA is subject to tax, maybe at 30 or 40% when you take the money out of it. And so is it really worth $200,000 to the spouse? And the answer is no. And so therefore, if I'm, again, the divorce lawyer representing the, say in our example, maybe a non-employee spouse or a lower earning spouse, I should be pushing to get assets that are after tax assets and not before. So those are probably
Wow.
the two main issues, just in terms of the types of assets you want to get. You want to get high basis assets, and you want to get after tax assets.
That is so incredible. I mean, my divorce was really pretty simple, and we kind of worked everything out ourselves without lawyers. But I can see now, yeah, people talk about how messy their divorces are, and I didn't realize that all these things need to be negotiated. So this is really, really great information. Okay, so you talked about that. So uh, how about whether a woman should be filed as a couple jointly or separately while they're going through the divorce process? Can you address that a bit?
Sure, those are actually very important points that you raise, Shira. Um, Number one, there are four main types of categories of filing that people should know about. You can file as a single person, and that would happen after you get your divorce. And you can file as a head of household, and we'll get into that a little later. You can, if you're married, you can file jointly, or you could file married, filing separately. So in the case of, let's say, a couple that's in the process of getting divorced, but not yet divorced, so the question is, should they file jointly or should they file as married, filing separately? Now, the tax rates on joint filers are lower than for married filing separately. So if you're judging it just based on numbers and nothing else, you would definitely say file jointly. The problem is that when you file jointly, you are also jointly and severally liable. So if, in part, the reason the woman is getting a divorce in this case is because she doesn't trust her husband in financial matters, and just because he files a return, he may or may not pay the taxes that are due, she may say, you know what, I'm willing to pay the higher rate of tax for the security of knowing that I'm not going to be on the hook for what my ex-husband's taxes are. So that's really the kind of fine line that you have to kind of evaluate. Am I going to file jointly and save money, or do I not trust my ex-spouse and therefore I'm rather going to file separately, even though it means paying a little more in taxes?
That makes so much sense. And also, I guess within that is if they're getting a refund back, right? If you're filing jointly, who gets that money? Because it only
Yeah,
goes into one
absolutely.
account. They can't split it 50-50.
That's right. And by the way, that's certainly any time that there is a potentially a refund owing. I think the divorce lawyer representing each side has an obligation to make sure that how that gets divided up is also put into the settlement agreement. And if they don't do it, then I think that's it's kind of like malpractice. So it's a very, very important issue, as well as the reverse, which is, let's say the couple knows that there are a few years in the past that there might be audits coming down the line because they've had audits in years before, and just because they filed returns several years ago, we don't know that that's final. If you're a competent divorce lawyer, you're going to make sure that the settlement agreement also says if there's some sort of a change in what the taxes are that are owing, this is how the parties are going to divide it up. And so that's a very important point that you bring up, Shira.
Wow, wow. This is so much more complicated, so I'm so happy you're here today. Okay, so then what about status? I know you touched on it a little bit. After the divorce is final, though, what is the best status for her to claim? And what's the difference between like single and head of household? When would you choose one over the other?
Mm-hmm. Um, you almost always want to file as head of household if you qualify. Every single person that pays for their own household expenses and that cares for one or more dependents,
Mm,
and that dependent or those dependents live with them more than half the year, are eligible to file as head of household, and you get a break in the tax rates and you get extra deductions that you're entitled to. So again, it reduces your overall tax bill. And so it's really important if you qualify to try to take advantage of that. Um, the issue is, I guess, how you're going to handle. Let's assume it's a couple that just has one child, so you can only have one head of household here, and both of you want it. So that's going to depend on getting into the marital settlement agreement. The fact that uh, the woman, let's say in this case, will have responsibility for taking care of the child more than half the year, and therefore is entitled to that credit. Um, if you leave that blank, you're just asking for lots of fighting afterwards because it can be significant dollars to each side to have that status as head of household. Now, if you have two children or more, you can be a little more creative because then maybe if the spouses are willing to work with each other, you can have child A stay with the mother a little more than half the year, 2 days more than half the year, and child B be with the father 2 days more than half the year. And
mm,
then you can potentially have each of them claim as head of household. So
wow.
a lot of it though depends on cooperation and the ability of the lawyers together with their clients to agree in the marital settlement agreement how they want to handle things. Because if they don't agree, then what often happens is each one tries to make a claim. The IRS catches it. They bring them both under audit, and it's a nightmare. So very, very important, if at all possible, to work out these things in advance. And that's why I said earlier, treat all these things like a negotiation. Just because it says tax doesn't mean that it's something that, whatever you say the tax is, it is, period. It's not. You have to negotiate these issues, take care of them, so there are no surprises later.
Wow, that's so amazing. So let me ask you a question. What if somebody has an adult child who moves back in with them and, is going through emotional or physical stuff, and the parents now take the one parent that the child's living with, can they claim head a household in that instance or not necessarily?
Um, I think as long as you have a dependent child living with you for more than half the year, and you're paying more than half of the upkeep of your home and all expenses, that you can get that status.
Oh, okay.
Yeah.
Awesome. Okay, let's see here. So So did you just discuss this? You may have in your point about is it better for women if the oh no uh, if the woman's the if she's the custodial parent in the divorce, should she claim or waiver her exemptions for her children?
Yeah, yeah, that's a very, very important related point to what we were talking about, and I think your timing is great in terms of including it now because that's really, really something that's worth talking about as well. There are a number of tax credits that the IRS gives to parents with mainly with younger children, with children 17 or under. There are a couple that go with children a little older as well. One of them is called the child tax credit, where for each child that you have custody over and are paying their expenses, et cetera, you get a tax credit of $2,000. Then there's something called the other dependent credit, and there it's a $500 credit, so it's much smaller, but it's for certain older children that again qualify. I think it's like mainly college age, that sort of thing. And then there's a third credit, which is called the child and dependent tax care credit, and that applies to money spent to try to get a job or to keep your job. So, in other words, let's say you have two parents, they're working, or a single parent who's working needs childcare for their kids. You can get a credit of up to I think it's $1,050 per child, or $2,100 total, no matter how for two or more children. You get a tax credit which kind of reimburses you for the amounts you laid out for childcare. Now, all three of those normally fall on the custodial parent. So, if in the marital settlement agreement the woman gets custody of the children, then normally she gets entitlement to these credits. But you are allowed to waive the credits if, on balance, you think they're going to be better off being used by your ex-spouse. And of course, with our theme of negotiation, you don't do that for free, obviously. You say, look, ex-husband, I'm letting you take these credits against your tax return. In exchange for that, when we divide up the assets in the divorce, I got to get a little credit for that. So you can do that. But mainly, I just wanted your listeners to be aware that they can negotiate away the child tax credit and the child and dependent care credit if it makes sense for them. Of course, they also have to understand what the impact is on them before they do that. And so step one, from my standpoint, is have your accountant sit down with you and do a kind of pro forma tax return so you get a sense of how much do these credits help me or not. They may not help you very much because you may not be working very much, and these are not refundable credits. In other words, they just reduce your tax, but they don't give you a refund. If you have already reduced your tax down to zero, you don't get a refund as a result of these things. So if you're going to get to that point where it only helps you if there's a refund, then you may say, hey, let me see if I can give it to my ex-spouse in exchange for which he'll give me certain other benefits in the division of assets.
Awesome. That makes so much sense. Okay, so let me ask you another question. Is it better for a couple, if they're going to sell the family home, to do that before the divorce before they get divorced or after it's finalized? Does that make a difference?
Excellent question. Excellent question. The answer is it can make a big difference. Depends on the facts and circumstances. Um, the rules are a little involved when it comes to selling your principal residence. The general rule is that, let's say you're a single person and you own a home, and you've lived in that home for at least 2 of the last 5 years before the date you sell it. If you meet all those requirements, and it was your personal residence, if you meet all that, then when you sell, the first $250,000 of capital gains is excluded, and you don't pay tax on it. So you bought your home for $250,000, you sell it for $500,000. If you qualify, then there's no tax whatsoever on the sale.
Wow.
If you're a married couple, that number jumps up to 500,000. In other words, each of you gets a 250, but you contribute it to the group, and that only applies when there's a joint tax return. So
Wait, I have a question because
sure,
I heard something wrong, or maybe you said it wrong, and I just want clarification. So
sure.
you said that if a single person owns a house and they bought it for $250 and they had it for more than 2 years and they sold it, you said for 500,000, then there was no tax owed. But wouldn't there only not be tax owed on the first 250, but the second 250 there would? Or did
Well,
you
well,
mean?
I guess let me clarify. What I meant was if they paid 250 for the home and sell it for 500, there's only 250 gain. 500 minus
Okay.
250. And so then, if that's the case, then they pay no tax at all because they get this $250,000 additional credit that applies to sale of residences.
Okay,
And if it's
perfect.
a
Thank you.
married
I was a
couple,
little confused there. So if I was, probably other people would be as well. So thank you for
and
clarifying
and,
that.
and
Okay,
probably I probably didn't say it as clearly as I should have. So I take credit for that. But if let's assume they paid 250, a married couple, and now they sell it for 750. If they file a joint tax return, then there's no tax at all. Same reason,
okay,
because you get it doubled in a case of a married couple, but only if they file jointly. So in this case, if you have a divorcing couple, it may very well be that as long as they trust each other, as we said earlier, you're not worried about one of them being a deadbeat. If they trust each other, it's almost always going to be better for them to sell the home before they get the final divorce decree. I mean, they could be in the process, they could be filing papers, negotiating, whatever, but don't pick up that final decree until you've sold first, and that enables you to file a joint tax return and get credit for that. If On the other hand, if they wait until after the divorce, then what's going to typically happen is, part of the house is going to be assigned to spouse A, and part of the house is going to be assigned to spouse B, and they're going to own it like tenants in common. They're going to own it like, unrelated investors in a property. And
hmm,
then each one of them gets a 250,000 limit. Now, offhand, you might say, well, what's the difference, right? You still have 500,000 in total, but there is a difference if, let's say, by the way they divide up the house, they agree that person A gets 65% and person B gets 35. Then it could be that person A has gain of, in our example, maybe 350,000, and person B has gain of 150. Well, person B is going to not pay tax, but person A is going to pay tax. So,
right.
so they would have been much better off had they decided to, sell the house before the divorce. Of course, it's not always possible. The real estate market and all this. Who knows? But I mean, if it's possible, it's always better to try to sell beforehand if you potentially have this issue of maybe one of them not using their full $250,000 credit afterwards, and therefore the other one, you know, having to pay tax.
Wow, great information. And I guess just the last, you know what, I'll give you, since we just have a couple minutes left, I'm going to give you, you know, a little bit of time if there's any other point that you think is really, really important, or, you know, if you want to be, you know, if people want to get a hold of you to ask specific questions, how they can do that. So I'll give you a couple minutes here to, and I'll put your contact information up on the screen here. And
Hmm.
please, you know, I'll let you have a couple minutes to say, follow up.
Well, thank you so much, Shira, and thank you again for inviting me. You know, I know from my experience that this is um, an issue that comes up, unfortunately, a lot after the divorce, when people realize that they didn't have the right representation, that they didn't take into account tax issues properly. And so I'm hoping, as long as your listeners know enough to ask their lawyers about these issues, it'll get raised and it'll probably be taken care of adequately. So if I've accomplished anything, that's really all I want to do, is make them aware of these issues enough to know that their lawyers have to deal with this in order for them to get the best results. Um, a couple of points that I would add is, number um, one issue that, believe it or not, I find is probably the most neglected in divorce is estate planning. You have a couple, they're very meticulous during their marriage to have an estate plan, and the estate plan says, when whichever spouse dies, the assets go to spouse two, and then when spouse two dies, it goes to the kids in equal shares. That's kind of a very universal, general estate plan. The problem is that when you get divorced, uh, there's no magic that automatically erases the name on the will and makes it someone else's name. And so if you leave that alone and then you die, um, your ex spouse very likely is going to get the balance of your net worth. Um,
Wow.
and so, and you wouldn't believe how many, both men and women, neglect to have their their wills and trusts reviewed after they get divorced. It is, to me, it's crucial. And to me, it's like, the first thing you should do once you recover from the trauma and all that of divorce is get on the phone with your estate planner and say, hey, I need a new estate plan. I got divorced. Because in some states, you can get the ex husband or wife out of the will, but you can't always. And so don't take a chance. There's no excuse for it. Get it done. It's not hard to do. You can more or less mimic what your old estate plan is if that made sense to you, but make sure you at least know that unless you want the X in there for some reason, the X is out of there. So
Right.
to me, that's vital. And the second point is with pension and estate planning things. A lot of my clients have the kind of thought that in a divorce situation that, well, my husband, has this pension plan in his firm. That's not something I really need to deal with in a divorce. That's part of his compensation, whatever, and forget about it. And you can, these days, a very substantial part of most people's net worth is tied up in pension plans and IRAs and similar things. And you better believe it's super, super important that your lawyer know exactly what's in those plans and makes provisions for how to deal with it. There's something called a quadro. That's an acronym for a qualified domestic relations order. And basically, that is a document you file with a court that tells the administrator of a pension plan, don't pay the pension monies to my ex, pay them to me, because in a divorce, I'm entitled to it. If you don't get that quadro done, you could have lots and lots of problems. So those are the 2 points that we didn't cover that I think is worth noting. Make sure you take a look at the will and have your estate planner take a look at the will and make sure someone knows every single non-cash asset that your ex has in his job, whether it's a pension plan, whether it's stock options, whatever it might be. Make sure you know about all that and that that's all provided for in your divorce as well.
Excellent. Thank you so much, Mark. So anyone want more information, you can contact Mark. You can email him at mark@hesstaxlaw.com. And thank you so much, Mark, and our audience for showing up today.